The precise issue that is presented to the court this morning on this case, on the Winbury case, is whether or not the Industrial Commission retains jurisdiction in permanent total disability cases to transfer the payments to a deceased, to the dependents of a deceased permanent total recipient. And obviously it's positions of the appellants, the dependents of James Winbury, that there's a specific statute that does permit that. That's 287.200 subsection 2, which says yes, they are permitted to retain jurisdiction and also to, in that respect, determine the dependency and issue the order transferring payments, which is post Schoemehl, which in January of last year permitted that.
And maybe I'm misunderstanding, but isn't the effect of your argument that then you could go back and relitigate it again and go up and relitigate it again and go up? Well, is there any finality under your interpretation?
I think the finality is determined by the particular case. There's certainly final decisions that are issued when the times for appeal would stop, but it's similar to any other type of case that can be brought back to court. I mean, one of the problems that we have...
But you don't get to argue things you didn't argue the first time. You don't get a second, third, and fourth chance to ask for something you didn't ask for the first time. You may be able to move to set something aside, different kinds of things, but here there's no request for payments to be made to the dependents. It was just to the claimant. I understand you didn't think of the argument until you saw Schoemehl, but that doesn't, when we have a change in case law, people don't get to go back and do a redo on earlier cases that didn't ask for some relief that a later case said was available. So I'm unclear how we can distinguish the situation you're suggesting, how we should interpret the statute here, and not open up every award anybody has gotten to for being looked at here.
Well, I guess specifically, if the commission was going to terminate my file, they probably should have done it, but at least they felt they had jurisdiction to do it. And because they didn't do it, I believe this case is still alive.
Ms. Schaefer, is your argument that the commission should make all necessary findings for purposes of Schoemehl at the time of an original award of permanent total disability?
That's correct. I mean, certainly the issue of dependency should be litigated and that evidence should be introduced. Otherwise,
determination of dependence when the claimant dies or when they're injured.
Under Schoemehl, the Schoemehl court says that dependency is determined by dependents at the time of the injury. Who is a dependent at the time of the injury? That's what Schoemehl says.
But obviously there's still, for purposes of Schoemehl, the issue of whether the claimant died from a cause not resulting from the work injury. That issue can be determined at the time of the final award.
That's correct, unless, as in the case of Schoemehl, the claimant was already deceased at the time it occurred. But I think there's a problem with that because under the statute, the commission can only look at or reopen cases for very specific reasons. And I don't see anything in the statute that would allow it to be reopened to determine whether a death was related to the accident or not.
Is this really a reopening or modification of the award, or is this just a question of whether the employer or the second injury fund's liability has ceased because of death? Isn't that really the issue?
Well, I think it's a question of whether it ceased because of death, but it all goes back to what was argued in the original case. And if we're now going to say in the 145 cases that the benefits were closed, now all those people can come back and say, wait, I had a dependent when I first litigated this, and now I want that dependent to get the money. I mean, that means there's no finality in permanent total or any other kind of judgment, because then if the law changes again, or if there's a new decision that comes out that expands or restricts what you're entitled to, does that mean every one of those then can be relitigated as well?
Counsel, I'm surprised that you didn't ask us to revisit the change.
Well, I would love to have Schoemehl revisited.
Is the legislature revisiting the statute?
They are. The Senate has already passed a statute that would say that Schoemehl is not the intention. It currently is in the House, but has not been heard in committee yet.
The Court of Appeals said that this case is different from Schoemehl because Schoemehl went to trial after he died. Fine. That is a factual difference. But if that's what we apply here, what then happens to these cases? You got a 30-year-old man, he's got kids, he's rendered totally disabled, If he wants the Schoemehl benefits for his children and his spouse, he has to wait until he dies and say, honey, when I die, you go ahead and pursue this case and get these benefits for you. He has to not collect total disability benefits, not collect medical benefits, and pursue his case, have his dependents pursue it after he dies. You know, that's ridiculous, obviously.
Schoemehl just said it was applying the law as written. It was just the first time it had come up, and therefore it would not permit them to raise something they could have raised in the initial trial.
That's correct. And all they need to do is at the time that it's tried say, these were my dependents at the time of the injury. And that last sentence that now reads, for the lifetime of the claimant, should say, for the lifetime of the claimant, and whatever, you know, and then to his dependents upon his death, should the death not be related to this injury, and then hear those pursuant to the change of conditions statute, 287-470. I mean, but that issue at least has to be raised. I mean, this is like, we have 145 cases out there where people are now going to say, oh, here's a new argument I should have made. Now I'm going to come back and make it. There has to be some point where an issue at least has to have been broached or raised at the initial time the case was tried. Or there really, truly is no finality, and much beyond that, there's no point where an employer or the second injury fund or a claimant is going to know that their award is going to stand as written.
If I have an award, and by the way, I looked at my award during the questions in the earlier case, it says to the employee for her lifetime or as modified by law. That's what the award says. Now, if I have to take that to the circuit court now, what I have is an award. That's all it says. What I have is an award to pay a dead person money that she's due, long back due benefits, those haven't been paid yet, and then prospectively going forward for her lifetime or as modified by law. The circuit court would say, well, I don't know how to enforce this again in favor of a dead person, and since the notice was given under 580, and it says may be revived, that's the procedure to go back now to the commission and say, okay, if 580 means anything, it means now we have to determine who the successor is in this claim so that we can get the record straight.
Yeah, I think that the reading of 287-580 is giving them a right to revive this case and now bring it in their own interest is a really broad reading of that. Because what it says is it may be revived and proceed in favor of the successor to the rights. Now, that's a successor to the rights of the claimant. He is reading that to say they can revive it and now bring their own claim as dependents. And I don't think that's what 580 says. If that's what 580 says, then you're really creating a whole new cause of action when somebody dies for their dependents. And that does not mean that they are then acting as a successor to the rights. I've never seen a case where it's allowed people that have already had their cases determined to come back and say, oh wait, now I want to make that claim too.
Assuming Schoemehl is correct, is the law in Missouri, that it applies to people who raise it, but the fact that somebody else raised it shouldn't let you go back and reopen cases to raise it when you didn't do it before.
That's correct.
Yeah.
Go ahead. Do you have any knowledge or is there any evidence in the record how many cases are out there that are in the same situation as the straight case where it was pending?
I believe that the straight case is the only one that I'm aware of where it was pending at the time.
And how many of the cases like accident there?
Well, there's 145 where the second injury fund has terminated payments. And then there is about over 800 where the second injury fund is currently paying those benefits. So we're talking about...
And every other one in the future.
And every other one in the future.
And the cases that you're talking about are cases where the death occurred before Schoemehl or after Schoemehl?
In almost all of them, the death occurred before Schoemehl. I think there's 3 where it occurred.
They were pending in some medical fashion.
Payments were being made on them at some
Aren't they
time.
were being made?
Right. The only one that I'm aware of where a death occurred while it was actually in the appellate process is the Rosenstraight case.
This one, right?
Yes.
Well, the 800 that are pending, the person is still alive, and so it's a question of would it apply after they're dead?
Right, because if it applies to Cox and Winbury, it's going to apply in every one of those cases when those people die.
Thank you.